All right, so we will start by defining estate, and that will be everything that a person owns and owes. So we're talking not just about assets, but also about liabilities. And in defining the small to mid-size estate, we're talking about an estate that does not exceed the estate tax exemption amount. Currently, that amount is $5.25 million if you're talking about a single client. If you have married or registered domestic partners and they both use their estate tax exemption, then we would be talking about an estate of $10.5 million or less. And the estate planning documents that we'll be talking about today are the most basic, and the four that we have here are the Revocable Living Trust, a will or a pour-over will, a durable power of attorney for property management, and the Advanced Healthcare Directive. So I'll start with the Revocable Living Trust, and that is an entity that is created to allow for management of financial affairs in the event of incapacity. So we're trying to avoid conservatorship through the Revocable Living Trust. And also the entity is created to ensure the efficient payment of debts and the transfer of assets to beneficiaries upon death, avoiding probate. It is helpful to describe the three parties that are involved in a Revocable Living Trust. The first party is the settlor, and you'll see different names for the settlor. It may be trustor or grantor or donor even, but that is the person who makes a trust. And so when you're working with a client, you can assure them they will always be the settlor of the trust, but the other two roles will change eventually. So the second party is the trustee, and this is a person or an entity who manages the trust assets, and this is oftentimes the settlor. In a Revocable Living Trust it will be, and eventually it will change to someone else when the settlor lacks capacity. The third party is the beneficiary, and this would be the person or persons or entities who receive assets of the trust. Again, this will be the settlor during the settlor's lifetime. So the settlor will be all three parties: the maker of the trust, the manager of the trust, and the beneficiary of the trust. But the roles of trustee and beneficiary will change at a future point. The Revocable Living Trust is revocable, and that means that the settlor may change or amend or cancel or revoke the trust so long as the settlor is living and of sound mind. The second document we'll talk about is the will. A will is a document by which a person directs estate distribution upon death. So compared to the Revocable Living Trust, which will exist from the time that it is signed, does not really do anything until a person dies. The purposes of making a will, first would be to choose beneficiaries. And the beneficiaries may be people or entities that will receive special gifts. Perhaps this would be cash or personal property that belongs to the testator, the person that made the will. Beneficiaries could be part of the residue, so whatever is left over after any special gifts. And we consider this different tiers of beneficiaries. So you may have a primary, you may have a secondary, and you can go down into as many tiers as a testator would like. And then dividing those tiers, if there are multiple beneficiaries, into percentages for them. So say that the testator had 2 children, maybe the primary beneficiaries would be the children, and the percentages would be 50-50. If there are children or other minor beneficiaries, maybe nephews or nieces, we would look at creating custodianships or trust for those minors. The second purpose of the will is to identify the executor or executrix, and this would be the person responsible for submitting the will to probate, so starting that court proceeding, gathering assets of the decedent, paying the decedent's creditors, and distributing the remaining assets to the beneficiaries as required by the will. The third and one of the most important purposes of a will, also used when a revocable living trust is involved, is to nominate guardians for any minor children. There are two types of guardians, and some clients will like to break these out. Guardian of the person is like a substitute parent for the minor child, so who will the child live with on a day-to-day basis, who will make health care and education decisions for the child. The guardian of the estate, on the other hand, is like the bank or the property manager, so who will be responsible for the minor's assets. Next document is a durable power of attorney. The durable power of attorney for property management is a document by which the grantor designates an agent, also called an attorney in fact, to make financial decisions during the grantor's incompetency. It's important to note that a power of attorney expires at death. The Advanced Health Care Directive can also be a power of attorney, although it accomplishes more than just naming an agent or an attorney in fact. And this document will pertain to health care decisions, again, when the grantor is incompetent and during the grantor's lifetime. So in addition to naming that agent, the Advanced Health Care Directive will also explain the grantor's wishes about medical treatment, what should or should not be provided. This is where you often hear of end-of-life decisions or the living will. So if you're in an irreversible coma, persistent vegetative state, if you do not wish to have life-prolonging treatment. And other things that can be accomplished in the Advanced Health Care Directive would be stating preferences for organ donations, disposition of remains, maybe a preference for burial or cremation, and services that the grantor does not want to have. So I've listed out different questions and then answers that can be provided to clients. These are probably the top questions that I get asked on a day-to-day basis. Of course, number one at the top of their mind is, do I need estate planning? Most people feel like I don't have that much. Why do I need to do this? So it's important to reassure your client that it's important to designate a person who is authorized to make financial and health care decisions. Nobody wants to think that that time is ever going to come for them, but it can, and it's important to have agents that can carry on the day-to-day financial management, healthcare decisions, just automatic for the next of kin to be able to. If the estate really is small, then let's focus on who will manage and distribute assets. So the trustee or the executor or the financial agent under the power of attorney, who is that person that can be trusted to carry out that duty, and also who will receive the assets, the beneficiaries. If there is no trust or will in place, then California has already decided under what we call intestate succession law who will be the administrator that the court will appoint to manage it, and who will be the heirs that inherit the estate. Another important reason to do estate, if you have minor children, appoint the guardian for them. Well, number two, I thought estate planning was for millionaires. Okay, estate tax planning is for millionaires. So big distinction there. Estate planning is important for everyone, even for people that have a negative estate. I sort of alluded to this with question number one, but some clients will ask, why do I need to do this? Can't my spouse or partner just take over and make decisions for me and receive my property? That's not how it works. That's important to have these documents if that's the desire. A spouse or registered domestic partner will have priority to be appointed as administrator of the estate or as conservator of the person, and that would be for and the estate, which would be for financial. But the authority is not automatic to go through a court proceeding in the absence of these documents. As far as if no trust or will, intestate succession law provides that the surviving spouse or registered domestic partner will receive all of the community property, but if there is any separate property, Maybe that was acquired before the marriage, or maybe it was a gift or an inheritance solely to the decedent. The surviving spouse or partner will only receive somewhere between 1/3 and 1/2 of that property. What is probate? Probate is a legal process in which the court validates the will, or it determines that there was no will. The court will oversee the collection of assets, the payment of debts, which happens over a 4-month period, and the distribution of the remaining property to the beneficiaries or heirs. What's wrong with probate? Why is it something that most people would want to avoid? It's very slow. 6 months I put here as a minimum. I've got a few people through in that amount of time, but more likely it's going to be 9 to 12 months. And again, that's for a small estate. It could be 2 years plus if it's an estate in excess of the estate tax exemption amount, or if there's litigation. The second problem with probate is that it's cumbersome. There are many steps that need to happen. It will seem asinine to the client. One of my favorites, is the duty to notify all heirs. So basically make a family tree of the decedent and go out as far as you possibly can and notify all those people, even though most of them aren't going to receive any assets. Third problem with probate is the cost. We estimate between 5 to 10% of the gross estate, of the gross probate estate. And the fourth problem is that this is a public process, so anyone off the street can find out who died, what did they have, where do all their heirs live, and eventually when that property goes to them, anyone can see that as well. How do I avoid probate? There are different ways to go about avoiding probate. One of them would be to co-own assets such that they have a right of survivorship attached. And so I put 2 different ways of accomplishing that. We have community property with right of survivorship. Now that can only be between a spouse or a registered domestic partner, or joint tenants. That is not dependent on marital status. Another way to avoid probate would be through a beneficiary designation on an asset. And that might be a pay on death, POD, or a transfer on death, TOD. It may be a life insurance policy that has named beneficiaries. It may be retirement accounts that have beneficiaries named on them. But a third way that probate can be avoided and can make sure that probate is avoided for most any asset would be to put the asset into a revocable living trust. And we call the process of moving the assets into the trust name trust funding. Number 7, do I need a revocable living trust? I get asked this question every day. The answer for many people will be yes, and the reasons why I've listed out here. First, to improve access to assets in the event of incapacity. And that's something that clients, again, usually overlook because they're invincible. But the trust is primarily for their benefit. Anything happens to them, they can't handle their own financial decisions, they can't pay their bills. They've nominated a trustee that can take care of this for them. The second reason to set up a revocable living trust is to provide for immediate access to funds. And mostly here I'm thinking to support minor children or other dependents. Their needs cannot wait for a court appointment. We don't want to have to go to a court to ask permission to pay for their bills or to family allowance. We want to be able to take care of them right away. The third reason for setting up a revocable living trust is to avoid probate. And that's the one that clients are going to be familiar with or most interested in. And it's strictly because of the financial cost and the financial benefit of not going through that process. So the cutoff that's important this question of, do I need a revocable trust, is based on the size of the probate estate. So if there is, and that real estate's gross value, contrasting here equity, but the gross value, if it exceeds $1,000, so most any property except raw land, don't have that in a revocable living trust, if you don't have that set up with a right of survivorship, such as property or joint tenants, then that property is going to have to go through probate. If you're not talking about real estate, if you're just talking about bank accounts, household items, the exemption here is a little bit higher. It's $150,000 is what we call the probate threshold. So if somebody really does have a small estate with no real estate, their accounts, the total of all of them is less than $150,000, then no, they probably don't need to worry about setting up a revocable living trust. If I have a trust, do I still need a will? Yes, everybody should have a will, whether they have a trust or not. If they do set up a trust, then they would set up a pour-over will. And the pour-over will is designed so that any assets that would be subject to the will would end up in the trust. And we look back up to the probate thresholds above. So we don't want the will to control real estate in excess of $50,000 or personal property in excess of $150,000. If you exceed those limits, that's when the will has to go to probate. If you're below that limit, you can avoid probate. A will is also important for providing for guardianship of minor children, so that may apply as well. Number 9, can I add my adult child's name that's now? I do see people doing what I call informal estate planning. They've come up with a solution of, well, I'll just add my child's name to property now, and then I won't have to worry about how it will be managed for me and how it will eventually pass to them. There are a lot of problems with that approach that people probably aren't aware of, and I've listed them out here. The first is the potential gift tax liability. So right now we have a $14,000 per year annual gift tax exclusion amount. That is the amount of property that can be given away each year to one recipient without a gift tax. If you add an adult child's name to a bank account or to a house, and that asset is worth more than $14,000 to the extent of the percentage that you're adding that child, you have a potential gift tax liability. That requires the filing of a federal gift tax return, and it's probably not the best way to go about it. The second problem of giving away property now, the loss of control of that property. If you put the child's name on the property, it's not just yours anymore. It belongs to the child, too. There can be situations that come up where the person that originally owned the property wants to sell it, refinance it, and now they need to go get the consent of the adult child. Another frightening concern here, number 3, is that by adding someone else's name to your property, you've now opened it up to their creditors. If they have a bankruptcy, if they are getting a divorce, these are all situations where you might have other people coming for that property that you consider to belong to yourself, but now it doesn't. Next, we have a significant tax reason to hold off on these transfers, and that's the stepped-up basis. So if the property would be held until death, at death the decedent's interest, if it were 100%, it would receive a 100% step-up in basis. If the decedent has added one adult to the asset, Now only 50% of the property, the 50% owned by the decedent, will receive that stepped-up basis. This can be huge when we're talking about real estate that has been held for a long period of time, stock that has been held for a long period of time. The appreciation has been significant, and why are we leaving open the door to pay extra income taxes on this compelling reason to not go about estate planning in this informal? Another less thought of reason would be that there is no protection if that child dies first, or what would happen if both of the owners would die together. Now there's no plan in place. There's no one left to manage the property or to inherit it. Another question that is commonly asked, are trust assets protected from creditors? And sorry, but the answer to that is no. If you control your assets, if you're the trustee of the trust, if you made the trust, your creditors can get them too. If you create a trust for someone else, an irrevocable trust, or if we're talking about the trust becoming irrevocable because now the grantor or settlor of the trust has died, then yes, there can be some creditor protection for other beneficiaries. So that can be another advantage of setting up a trust, but it won't protect the settlor of the trust. And my favorite question, do I need an attorney? I hate to have to even answer this question, so I put down a few responses that you may give to clients that ask why they can't use LegalZoom. How much does an estate plan cost? That's a good question and something to decide at the outset of the engagement. Of course, if the anticipated fee would exceed $1,000, you're required to have a written legal services agreement, and that legal services agreement should explain how much the estate plan will cost, whether that's going to be done at the attorney's hourly rate or it's being offered at a flat fee. If it's being offered at a flat fee, you want to be very careful to define the scope of the engagement, what is included in the estate plan. If a client has 10 properties, are you preparing all 10 deeds for that flat fee, or do you have a certain number that you may prepare and then you would charge extra if there are additional assets, or it may depend on the type of asset. You might want to specifically note what is not included in the estate plan in terms of future amendments to the estate plan. Clients will often ask about that, so you might let them know that the First Amendment is included, or I offer a continuing plan if you would like to make amendments, and here's what that plan looks like. Or what I do on this is, if a client would like to make changes in the future, that's going to be a separate agreement, and then we can determine what those changes are. Are they significant? Are they minor? Okay, how do I get started? This is a good question and one that we want to work with. How do we get started on the estate plan? How do we go about working together? I have an estate plan questionnaire that I will send to prospective clients before the initial meeting. And attorneys vary in terms of how do they go about that questionnaire because it is quite lengthy. Mine is a 10-pager, and that can be intimidating for clients, especially clients that do have a smaller estate, or they're younger, or it's just their first time thinking about this, and it's not the most pleasant thing to think about anyway. So you want to think about, well, how much do I want them to do to prepare for the meeting, or how much am I going to go through with them just walking in the door and not really having considered any of these questions ahead of time. So I do encourage anyone that I'm meeting with to review all the questions. If they have a significant other, make sure that they discuss those questions so that I don't have to witness a fight about who will be the guardian of their children and the family members that they don't like. But I know some attorneys that will go through that questionnaire for the first time with a new client, not ask them to look at it. And I know other attorneys that will expect it to be filled out as much as possible before they volunteer their time. So I hit on the legal services agreement and some things that should be included there. The next step of the process, once you have a completed questionnaire, I explain to my clients that serves as my outline to draft their documents. And once the documents are prepared, then you want to decide how am I going to transmit the documents to the client. I choose to do that via email whenever possible. For some of the older or less tech-savvy clients, that ends up being a mailing, or for some of them it might even be an in-person review of the documents. But at any rate, you want the client to review the documents and make sure that and what they will be signing, and that the documents obey their wishes. There are a lot of provisions that an attorney might include in these documents, and you might point out which you've inserted, which the client has some say over, versus others that are sure. And the next step would be executing the documents with the clients. Some attorneys will do that in person with their clients. Many estate planning attorneys are notaries, and that's very convenient. Others may send the documents with signing instructions. I know I prefer not to do that. Just seems like they often come back not executed properly. There tend to be a lot of signatures, and it's easy to miss something. And I think it also makes the client feel more confident when they've signed the documents with their attorney, and the attorney has gone through the documents and explained maybe at least an overview of signing, reiterate why it's important. From there, and this is something that you may address in the agreement with the client, is the responsibility for funding the trust, updating beneficiary designations. Is it something that the attorney is going to do? Is it something that the client is going to do? What I do is prepare a list of all of the client's assets and liabilities and identify the action to be taken with each asset. To the extent that I can make those changes, then I would do that. But of course, there will be things that you cannot do for your client, like changing the title of their bank account. So I identify the items that the client is responsible for, and then tell them it is.
I'm sorry, Nicole. I'm actually going to, I don't mean to interrupt. This is Meredith again. I just wanted to remind everybody that there are a few callers that I think unmuted themselves. If you can just make sure that that your line is muted, and if you unmuted yourself at any time by pressing *6, if you could press *6 again, it's very important for the audio quality that everyone be muted. So thank you so much for your assistance with that. And again, I'm so sorry for the interruption.
That's okay, Meredith. Thank you. Okay, I do want to really stress, though, the importance of funding the trust and making sure that the beneficiary designations are up to date. There's not an ex-spouse named. There's not a deceased parent named. There's not a friend that's no longer a friend named. I don't know how many people in the audience, in addition to doing estate planning, also do estate administration. But this is where you find out when the estate planning was incomplete, and it's certainly not something that you want to be going through on the back end of an estate plan that you set up. It's really important to understand how everything ties together and make sure that when that crisis moment comes for the family, that this is going to be as smooth as possible of a transition. And you might also, I did hit on this, but talk to the client about the ongoing maintenance of the estate plan. Is that something that the attorney is going to do automatically? Is it on a plan? Or is it something that the attorney is not responsible for unless the client contacts the attorney? Okay, so I've listed out some planning issues that I think will be helpful in conversations with clients. One question that's often asked is, how do you choose the fiduciary? And the fiduciary is going to be the trustee of the trust after the client, the executor of the will, the agent under the power of attorney and the healthcare directive. And so at a minimum, to qualify as a fiduciary, the person needs to be at least 18 years old. Many clients will consider their parents or other people that are older than them, and that's perfectly fine, but you want to stress the importance of having some younger people, too, that are likely to outlive the client. We do have a preference for contemporaries, and I think the reason for that is we expect a similar life duration. We expect more similarity just in terms of knowledge of the finances and technologies, and I think it's easier working with someone that's the fiduciary if they are a contemporary, but that's not always the case. Ability and willingness is a requirement. Just because someone is named to be an executor of a will, for example, doesn't mean that they're required to accept that position. And so some clients of mine will ask, do I ask the people ahead of time? I think that's a good idea to find out if they would be willing to take on that position. If they say no, best not to list them. Even if they say yes, it may be that when that time comes that they're not around or not able or not interested in doing it. So I do think it's a good question to ask, but it's not a requirement to ask, and so some clients won't ask that question. But in that case, I think listing a number of successors becomes more important so that someone will be able and willing to take on the duty. Other considerations that are important here, geographical proximity. It's not the end-all, be-all, but California residence is helpful, especially if we are looking at a probate situation. The court does have discretion, at least I know Contra Costa, where I primarily practice, may require a non-resident executor to post a bond, even if the will states that no bond is required. So California residence is helpful in that regard, and also just the ability to take care of things and being close is helpful. Having someone on the East Coast, no problem. I've done that before. Having someone that is not a U.S. person. This is something that we always want to identify, and we really, as attorneys, need to ask our clients this question. Practicing here in the San Francisco Bay Area, I'd say a third of my clients will list people initially that may not be U.S. persons, and so it's vital that that question be asked and that the person be advised it's not that you're prohibited from naming a non-U.S. person as a fiduciary, but there are tax implications of doing that with regards to a trust. If a non-U.S. person will be the trustee, that will cause the trust to be taxed as a foreign entity, and that's not desirable. Next consideration we have here is conflict of interest. A conflict of interest could become grounds for removal of the fiduciary, but whether it actually leads to removal or not, it's a good question to ask. If I'm listing somebody to be a fiduciary and they are the sole beneficiary, well, that's probably a good thing because they have an interest in getting it done, and there's not really too many people to have a conflict with. If there are multiple beneficiaries, it can get more dicey there, especially in the situation of children. So choosing one child to be the fiduciary and the other children may not get along with that child. There may be a family history there. The selected child may not do a particularly good job of being a fiduciary. These are all things to think about in drafting the estate plan so that we can minimize any potential problems. So the family dynamics, hit on that. Having an individual versus a professional fiduciary. I'm actually quite biased here in favor of having an individual whenever possible as a fiduciary, but for some clients that's not going to be realistic. Maybe they don't have any family available maybe they don't have any decent family that's trustworthy enough to take on that position. And so for those clients, it is a good idea to look into a professional fiduciary, and that might be someone where they bank, brokerage firm. It may be an individual that professionally provides that service and is registered with the state to do so. And then the last consideration I have here is co-fiduciaries. So going back to the example of children, can you name all of them to be fiduciaries together? Yes, you can do that. And I always tell my clients that that means that they need to get along, or that there needs to be a majority vote before actions can be taken. So it's not necessarily going to make things easier to name co-fiduciaries. It seems to have got to the point now where even when you put a provision in the trust that tries to override the default and say that one fiduciary may take actions or fiduciaries may delegate to other fiduciaries, that some institutions will not appreciate that, and maybe for their own protection they want all the fiduciaries to sign or to make decisions, and that can become rather inconvenient during an administration. If you are going to name co-fiduciaries, in addition to how they will make decisions, you also want to address the replacement of a co-fiduciary who is unable or unwilling to serve or continue to serve in that position. So would they be replaced by someone else? And you may see this with families maybe where a husband wants to name one of his siblings as a co-fiduciary, and then the wife wants to name one of her siblings, and they feel like that will keep the family together and make everybody happier. Or you may provide as an alternative that instead of having a replacement of the co-fiduciary, that the remaining fiduciary or fiduciaries will serve at that point without anybody else being added. Okay, selecting the guardian of the person. Probably the worst of all these to think about, but who could be a parent to your child, who would be willing to be like a parent to your child, who would take on that great task. So some desirable characteristics helps for discussions between spouses and partners to identify why they believe somebody is a good choice or a bad choice. The first one I have here is age. We need them to be at least 18 years old. Again, the preference for a contemporary or someone younger. They need to be physically and emotionally capable of raising a child. It's important that they have a good relationship with a child. This is really going to be relevant to the child who is going to have the change of situation. So when the child's old enough, you might even ask that question, or maybe not ask, if I die, who do you want to become your new mom or dad, but who do you which of our friends do you like, or how do you like hanging out with Uncle James? It doesn't need to be a family member, maybe a close friend. A long-standing and stable relationship with the family is very important. Cooperation with the guardian of the estate. If the person that will be managing the child's trust or managing the child's assets, because there's a will in place and now we have a guardian of the estate through the will, if that will be a different person or entity, we want to make sure that there's going to be a good working relationship there. Again, geographical proximity. It's helpful for the child to maybe not have to move to a new school or to a new state or a completely new environment on top of the changes that are already being dealt with. Again, California residence is not a requirement, but a bond may be required, again, even when a will waives a bond if California residence is not present. And then marital status is going to be an important consideration. There's no requirement that a guardian be married, but being a parent, I do think it is helpful when you can have two people in a household to help with a child. Having a spouse or a partner who is able and willing to do that is a positive thing in most cases. But we also run the risk that the couple may split up. There's still a high prevalence of divorce and separation, and so it may be a good idea to address that in the will If the couple splits up, we would instead choose someone else as a guardian. Or if the couple splits up, then I would prefer my sister and not my brother-in-law to continue being the guardian, as an example. Okay, the next few slides are going to talk about devises, and there are different types of devises or gifts made through trusts and wills. And the first one that I'll talk about is a specific devise, and that is where we are making a gift of specifically identifiable property. The intent behind the gift is to give that specific thing and that thing only. An example of this, I give my house, and here's the address, to such and such a person. And whenever a gift of real estate is involved, we want to address if there's a mortgage or liens, even if there are not now, what if there are in the future? Do we want those to be exonerated, which means to have them paid off from other assets, or will the gift be made without exoneration, which means that the new owner, the beneficiary of that property, would need to assume the mortgage or pay it off, be responsible personally for those liabilities. Specific devises have limited usefulness. We don't know when we're going to die and what we're going to own at that time. If a devise is specific and the property is no longer around at the time of death, then the gift is not going to be made, and we call that exemption, noted there at the bottom of the slide. Another issue with specific devises is that asset values can change dramatically from the time that a document is prepared until the time of death when it will be executed, and that can lead to unintended results, particularly when clients execute estate plans and then they never look at them again and they die 10, 20, 30 years later. I've personally seen this happen in my practice where cash gifts that seem rather small at the time were made and the estate was spent down, and now one or two people that were intended to get rather small gifts in the big scheme of things ended up with the bulk of the estate. There's also the issue of abatement. So if specific devises are listed out and there is not enough property in the estate to satisfy all the debts, the expenses, taxes, and to pay those gifts out in full, then the drafter might state whether a specific devise will receive preference over others or how that will be handled. Are they all abated proportionally or equally? Good thing to state for clarity for the beneficiaries. An alternate way of making a gift would be a general devise, and that is to say that instead of specific property being given away, that just generally from the estate property will be given. I've listed a couple examples here. A cash gift of $10,000, a gift of stock in a corporation, all personal property. The advantage of a general devise compared to a specific devise is it will not be subject to exemption, and so that's good to note. Demonstrative devises, this is a type of a general devise, but then it will specify the primary source where the gift could be made. So, for example, I give a cash gift of $5,000. I would like for that to be paid from the sale of my Apple stock. Maybe the Apple stock aren't around at that point, or the trustee doesn't want to sell them, then it's possible that the gift could be satisfied elsewhere out of the general assets. The residuary is everything that is left after debts, taxes, and special gifts. An example would be all the rest of my estate. That's one way that we could word the residuary devise. It is most often done that the residue will be divided among multiple beneficiaries and that we will name fractional shares to specific people or to a class of people. Like if you have a younger client and they haven't started having a family yet or are not done having a family, you may want to provide the class gift will be to their class of children, and that way it will include any future born or adopted children We can use per stirpes language to provide that the deceased children's shares go to the grandchildren, etc. The anti-lapse statute goes here, so I always list this out whether the anti-lapse statute would apply or not, just for clarity for the beneficiaries who probably don't know all these legal definitions. If the beneficiary does not survive and there is a certain relation there, then the issue of the decedent would take in that place. So, for example, if in my will I stated that I leave my property 50-50 to my brother and my sister, and I don't state anything further, but my brother predeceases me, his share would go to my nephews, my brother's children. Still, I prefer to state that out so everyone knows that that's what will happen. A conditional devise. Some clients will ask for this. There's no definition in the probate code for a conditional devise, but they are allowed as long as the conditions imposed are not illegal or void as against public policy. So an example of something that is void is restraint on marriage, a provision that states I leave my house to my husband, but only if he does not get remarried. That's not a good way to state the condition because it would not be legally valid. But mixed case law does suggest that there may be a way to restate the intent in a way that we would not be violating public policy. And so if an attempt needs to be made at that, the gift might instead be stated that the reason for preventing the remarriage is that we assume that the spouse would need the property, but if they get remarried, then their need for support has been satisfied. The drafter will want to consider what should happen to that gift of property if it's subject to a condition and that condition fails, and it's best to state that out if there's an alternate recipient of the property or if the gift will lapse entirely. And maybe better to do this through a trust than through a will. Devises to minor beneficiaries. We always need to address this because the minor's parent does not automatically control the minor's property. Property can be put into a minor's name and then essentially frozen until the minor reaches age 18. And besides, age 18 may not be when we want people making important financial decisions. So different ways to go about the devises to minors. The first is that if the gift is going to be very small, like up to $5,000, then that's fine to not state anything because legally that is allowed. Also, if there will be a gift of cash only and the gift will be $20,000 or less, then that can be handled with a court order. So, perhaps the most simplest estate planning where you're not doing a trust, you're only doing a will, you're giving away really small amounts of property. It's okay not to add what will happen for management of that property. A guardianship would be appointed by a court and overseen by a court. If the amount of property is larger, then there could be a trust put in place, and this will have multiple advantages. Of course, avoiding guardianship. My favorite here is second, and that's that the trustee can be given a flexible discretion, so whatever the minor's needs might be, the trustee can determine that and see that they are satisfied. Can stagger out payments. This has become really popular with a lot of my clients, and I've seen this with other attorneys' clients too, where they might do something like a third of the inheritance at 25, half at 30, and the rest at 35. So give the minor an opportunity to learn how to responsibly manage their inheritance. And if they made some mistakes at 25, they still get 2 more chances to make better choices. Another reason to have a trust would be to delay the beneficiary's control without having to worry about an age limit whereas we'll talk about the Uniform Transfers to Minors Act, the custodianship, that can only be used up to age 25 if a gift is made at death, or up to age 21 if the gift is made as a lifetime gift. So a trust will allow us to go past that age, and that might be especially relevant to adults who we know are not going to be able to make their own financial decisions or not make good decisions, or, as I have down below, welfare recipients, because we don't want them to lose the benefits that they're receiving from the state. It's important that they have a special needs trust in place. Funding the trust. What assets do we need to put into the trust? Any U.S. real estate, and then contrast below, foreign real estate is not going to be put in the trust, I think, in most, if not all cases. Stocks, bonds, and investments, these are things that should be put into the trust. I prefer that the ownership be changed to the trust, not just that the trust is a transfer on death beneficiary, as many brokers like to do because it's less paperwork. But actually changing the ownership allows for a smoother transition. If the settlor becomes incapacitated, now we can manage those investments through the trust, and we're not relying on the power of attorney, which can be more challenging. Savings accounts, especially if they're larger, those need to be put in the trust. Contrast below, a small checking account, like people keep a bill pay account, that does not need to be put in the trust. If you recall back earlier when I talked about the $150,000 probate threshold, hopefully you're not keeping that much in your checking account, earning nothing. Move that into a savings account or somewhere else and then put it in the trust, but the everyday checking account, usually not put in the trust. Life insurance, there's no need to change the ownership to the trust, but the trust should be the beneficiary of the life insurance policy in most but not all cases. Other things that do not go in the trust, retirement accounts usually do not name the trust as the beneficiary, but it will depend on the specific situation. There are times that it is appropriate, but this is something that if you're new to estate planning, you really want to be cautious here, because if you name a trust as beneficiary, you could be foregoing some income tax benefits, and you want to be aware if that's the best option, or if there's something that can be done within the trust to structure it so that it will not lose those income tax benefits for the beneficiary. Drop down to personal vehicles and household items. Those can be put in a trust, but they usually don't need to be. Again, they usually are a smaller value and so below the probate threshold. Okay, so if you're dealing with a married couple or registered domestic partners, then you want to talk about not just the first estate tax exemption, but what about the second estate tax exemption? This will not apply for registered domestic partners, but for spouses, we currently have portability in place, and that means that the surviving spouse may use his or her last deceased spouse remaining unused estate tax exemption amount. The requirements to qualify for portability is that the first spouse must have died in or after 2011 when portability became the law, and second, that the surviving spouse needs to file an estate tax return and make an election for portability. So this is an opt-in. If you don't opt in, then you throw away your spouse's estate tax exemption. So this will be something to consider mostly for clients that are hovering around that $5 million mark, and they may go over it, but you want to consider whether the estate is growing or decreasing. There are a number of factors to think about here, and when in doubt, I think it's best to file the return and elect portability so that the exemption is not lost. The advantages of relying on portability as a component of the estate plan as opposed to more complicated trust schemes is that this is a most simple arrangement for the surviving spouse. The survivor will have more control of the assets, ability to do pretty much whatever he or she wants with them, and to change the beneficiaries. And this can be beneficial, especially if there may be changed situations that we want flexibility to be able to adjust the plan, and that may have been in a way that whoever dies first would have agreed with. Of course, there's also the potential that the estate plan has changed in ways that the decedent would not have approved of. So that's another thing to discuss with the client. As far as taxes are concerned, if there is not an estate tax issue, or we're assuming that there's not because this is the small to mid-size estate, there is an income tax benefit of not splitting up the trust into multiple trusts, but instead relying on portability, and that's that all the assets that belong to the surviving spouse, they will all receive a basis adjustment, the stepped-up basis, when the second spouse dies, and so that is very beneficial for the beneficiaries. They get a current market value at date of death. If they turn around and sell the assets, they are not going to have to pay capital gains if they haven't had a gain since the date of death. A disclaimer trust, I think this is still really popular. I still include it in all of my simpler trusts, just in case. I mean, this is supposedly a permanent estate tax law, but I don't believe that. So I like to keep flexibility just in case the exemption changes, the client's estate changes, and we can still use this wait-and-see approach. If we want to rely on portability, we'll have that option. If we want to make a disclaimer, we can create what will function like a bypass trust for the surviving spouse. And talking about the bypass trust, the credit shelter, the exemption trust, it's really beyond the scope of this presentation. Unless you have a situation where you have a smaller size estate, but you have a need for control. And so let's start with the definition here. The bypass or credit shelter or exemption trust, this means that when the first spouse dies, the trustee is going to split the trust into a survivor's trust, which I call A, and a bypass trust, which I call B. Trust A is going to receive the survivor's share of the trust property. It may be half, it may be more or less than half. Trust B receives the rest of the property, the decedent's share. Trust A is revocable. Trust B becomes irrevocable when the first spouse dies. This will remain the preferred approach if we want to have control. If the one spouse dies first and they want to know where their property is going to be going, then this is still going to be best for that family. And you'll see that with blended families where they don't have children in common, that there is a great desire to protect the children from being written out by the wicked step-parent. There may also be a concern, and this may or may not be in a blended family, it could be in a first marriage, but one spouse, and it's typically the wife, but amusingly not always, will be concerned, what if I die first and then my spouse goes and marries someone else and I don't want that next person to get everything. They may feel a need to control and make sure that their other family members or charities or whoever they know and like will receive the property. The advantages of continuing to use this bypass credit shelter arrangement is that it will shelter future appreciation from estate tax, whereas portability, you know what amount you're getting, you don't get that exemption amount until some future point when the second spouse dies, and it may be that the estate has increased and it would have been desirable to keep that appreciation from being subject to estate tax as well. This will also be relevant if you're going to be doing planning that involves skipping generations for beneficiaries and you need to preserve the generation skipping transfer tax, GSTT exemption, or if there's a need for creditor protection. And the last slide I have here, I think this is helpful to give the client at the conclusion of the estate planning process and let them know that when do you want to review and update potentially the estate plan. So I've listed out the big changes that might happen in life that may affect the documents, and it would be a good idea to review and see if the wishes are still intact or if an amendment needs to be made. As far as attorney reviews, I tell my clients at least every 5 years, check in with me, let me know how things are going, and I'll let you know if there have been any big legal changes. And we'll just keep watching out for any big tax changes. We're certainly not expecting them, but one